Good morning. This is Justina Grado talking to you from, prison or the juvenile delinquency system. In other words, I am a hostage. This recording is unprovoked, however necessary. I am reading from the Alberta Court of Justice website, the domestic court, and I have been going through the domestic emergency sanctions and segregations for more than 7 years since my divorce. Domestic court. Since 2000, specialized courts focusing on domestic violence cases have been set up in Calgary, Edmonton, Lethbridge, and Grand Prairie. Domestic violence courts recognize the unique characteristics of violence between family members. They emphasize the importance of early and effective intervention in abusive situations in order to increase victim safety and allow for a greater chance of offender rehabilitation. These courts serve to hear cases involving allegations of violence between intimate partners, including allegations of harassment, elder abuse, and crimes against children under 16 years of age. These courts work with social service agencies, or in Calgary, CFS, and workers to provide support services for victims and require offenders to take responsibility for their actions, not only through regular legal sanctions, but also through monitoring and counseling. This integrated approach emphasizes treatment at the earliest opportunity and has produced significant results, both in terms of dramatic reductions in recidivism. Statistics from Calgary show that 83% of first-time offenders do not reoffend within 3 years of intervention by the program, and significant increases in the levels of satisfaction with and confidence in the justice system by complainants and other participants. Now, this reading addresses mental health. I have been diagnosed with Bell's palsy, which is why you see half of my face drooping. One of my wards of care, no name involved, was also diagnosed with Bell's palsy, which is an infection. It's not contagious. It just happens. I don't know why viruses happen. I'm no fan of science. I am also going through the flu. The Edmonton Mental Health Court MHC program helps address the overrepresentation of people with mental illness in the justice system by focusing on underlying mental health problems that often contribute to repeated criminal behavior. The MHC is available for adults aged 18 years or older who have been charged with a criminal offense and have an ongoing mental health issue that affects or impairs judgment, individuals with a brain injury or head trauma, including fetal alcohol spectrum disorder, FASD in some cases, and those with mental illnesses such as schizophrenia, bipolar disorder, and major depression will also be considered. Admission to the MHC is based on the following criteria. There must be a reasonable basis to believe that an accused has a brain injury, neurological deficit such as FASD, mental illness, or mental disorder. There must be a reasonable basis to believe that there is a relevant connection between the mental health condition of the accused and the alleged criminal offense. The accused must consent and be motivated to participate in MHC, and the alleged criminal offense must not be subject to exclusion under the MHC criteria. Excluded offenses include murder, drug prosecutions unless a federal prosecutor consents, prosecution handled by special prosecutions, breaches of long-term offender orders, or of certain peace bonds. Cases involving domestic violence usually do not qualify. Only a justice can formally refer accused persons to the MHC, but counsel can recommend a referral at any stage based on their own observations or based on input from others, such as police, a justice of the peace, or family members. The MHC functions like any other court in that the Crown and a defense counsel generally determine what information is placed before the justice, and counsel make recommendations to the justice as to how a matter should be dealt with. However, this court differs from conventional courts based on an adversarial model. This court takes a more collaborative approach and enjoys extra resources to help the court identify and address the issues underlying the criminal behavior. In addition to Crown and Defense Counsel, there is a mental health worker in the court. A social work navigator is available to help accused persons access resources in the community and navigate the system, and a psychiatrist is in regular attendance. The third reading now is based on trafficking. Traffic court is part of the Alberta Court of Justice. It deals with offenses pursuant to many provincial statutes and regulations, municipal bylaws, and a few specified federal statutes. In spite of its name, traffic court is not limited to only hearing traffic-related offenses. Traffic court does not deal with most offenses created by federal statutes, such as the Criminal Code and the Controlled Drugs and Substances Act. Young persons aged 12 to 17 years of age who are charged with a provincial offense are dealt with in the Youth Division of the Alberta Court of Justice. In some court locations, there is a distinct youth traffic court. Trials in traffic court, whether involving an adult or a young person, are usually heard by a justice of the peace. However, in some locations, trials are heard by a justice of the Alberta Court of Justice. Only justices of the Alberta Court of Justice can hear traffic matters in the following matters: any proceedings that involves the death of an individual, any proceeding that involves the determination of whether any charter rights have been infringed or denied, any issue relating to the constitutional validity of any law, or any proceeding that involves a determination of any Aboriginal or treaty rights. The majority of offenses in traffic courts start with a violation ticket. The violation ticket will specify the charge and provide information about how and when a response must be made to the ticket. Many violation tickets don't demand a court appearance. However, some violation tickets will specify that a court appearance is required. Charges in traffic court can also commence without using a violation ticket, in which case a person charged with an offense will receive a summons of some other form of court process that will indicate when and where a court appearance is required. A person receiving a violation ticket or other court process involving an offense should carefully review the document to determine what action is required or permitted in response to the violation ticket or court process. This last reading is regarding youth, or the opposition of using minors. In Canada, there is a separate youth justice system for young people from the ages of 12 to 17 that are accused of committing a crime. Understanding how the youth justice system works will help you to make decisions about how to deal with your situation. This website is intended to provide information only. Being charged with a crime is serious, and you should speak to a lawyer about your options. If you are charged as a youth, you are entitled to a free lawyer through legal aid. When you contact legal aid, they will explain more about the process for you. Youth Criminal Justice Act, YCJA. The Youth Criminal Justice Act contains rules and procedures that apply to young people from the ages of 12 to 17 that are charged with a criminal offense. The YCJA was created in order to ensure that the consequences for young people who break the law are balanced. One of the principles of the YCJA is that while young people must be held accountable for their actions, they should not be treated the same as adults. The YCJA emphasizes rehabilitation, or the opportunity for youth to mature, learn from mistakes, accept consequences, and make amends. The following links explain more about the YCJA. Center for Public Legal Education Alberta, YCJA poster. Department of Justice Canada, YCJA resources. Alberta Government, 2013 YCJA Pocket Guide. More information. These publications give more information about how the different steps in the youth court process work. These publications are intended to provide information only. Being charged with a crime is serious, and you should speak to a lawyer about your options. If you are charged as a youth, you are entitled to a free lawyer through legal aid. When you contact legal aid, they will explain more about the process for you. Youth Justice Court and youth penalties, youth judicial interim release bail hearing, youth appeals and reviews, youth records. Thank you, and don't hesitate to present yourself in court.